Hello everyone, Benjamin Gottlieb here with Gottlieb Law. I'm here today to talk to you about a recent Arizona Court of Appeals case that came down in October of 2024 affecting HOA law as well as short-term rental law. The case involved a Pinetop HOA community where the HOA sought to ban short-term rentals. The Arizona Court of Appeals in October of 2024 issued an opinion basically saying that the amendment by the HOA to ban short-term rentals was invalid and violated the principles set forth in a 2022 Arizona Supreme Court case, the Kalway v. Calabria case. It's just a quick reminder for everybody, the short-term rental law in Arizona is very interesting and has evolved significantly over the past 8 years. In 2016, the Arizona legislature passed a state law that essentially tied the hands of towns and cities, preventing them from banning short-term rentals. And while the law provided statewide uniformity, it allowed for HOAs to bypass the state law and to amend their governing documents to prohibit short-term rentals through a CC&R amendment. And while that's been the primary vehicle for banning short-term rentals over the past 8 years, in 2022, the Arizona Supreme Court came down with an opinion, the Kalway v. Calabria case that involved a Tucson community. And in that case, the Arizona Supreme Court said that essentially you need to have an amendment be reasonably foreseeable in order for it to be valid if you're going to invoke a majority vote procedure that is set forth in the governing documents. And if it's not reasonably foreseeable to the homeowners based on a review of the original declaration, then courts should scrutinize that amendment and declare it invalid. So a really interesting development in Arizona law and really provided additional protections to short-term rental property owners, even though the 2022 Arizona Supreme Court case did not actually deal with short-term rentals. It was an HOA case. It dealt with other amendments. Real estate experts across Arizona quickly speculated that there would be a wave of challenges to short-term rental bans in HOA communities through the amendment procedure. And sure enough, that is what occurred. And that is the case law trend that we are seeing as late as October of 2024, where we saw the Pinetop Community Court of Appeals case, where the Court of Appeals struck down the amendment and declared it invalid. So really, really interesting. And on the other side of the aisle, we have seen a wave of legislative amendments that have provided further regulatory tools to cities and towns to crack down on and to regulate short-term rentals. We saw the first wave of amendments come in 2019, and that was where we saw cities and towns being empowered to provide additional regulations, such as forcing the homeowner to provide their emergency contact information to the Department of Revenue so that they would not be able to hide behind complaints. We also saw additional regulatory tools allowing cities and towns to provide fines for nuisance-type behavior. And then in 2022, we saw even yet more amendments that were enacted. And based on the 2022 amendment, cities and towns can now require a property owner to obtain a short-term rental license. Also, they can provide a homeowner with the requirement to give notice to the neighbors that they're going to operate a short-term rental. And ultimately, a city or town can even suspend a short-term rental operator's license for 3 serious violations in a 1-year period, or for 1 violation if it's a felony act and a serious attempted felony act. And we saw this take place actually in the city of Tempe. It was a newsworthy story. But in 2023, there was a shooting incident that occurred at a short-term rental property. Sure enough, the city of Tempe, relying on the new regulatory tools at its disposal, suspended the short-term rental operator's license for 1 year. So if you're a short-term rental proponent, you're going to like the recent case law trend that is providing more and more protection to short-term rental operators. The primary vehicle that HOAs have used to ban short-term rentals over the past several years is facing more and more challenges based on the Kalway case. And if you're a short-term rental opponent, you're going to like the recent legislative amendments that we've seen go into effect that are providing greater regulatory tools to cities and towns to crack down on short-term rentals. So that's what I wanted to talk to you guys about today. And as we see more and more case law come into play, I'll be back to provide additional updates. Thank you very much for your time.